Good evening, everyone. It's evening, right? I'm standing between you and drinks. That's not a good thing, but I promise it won't be that long. It's really a delight to actually follow the last panel, as well as the speaker, or the two who came before, because a lot of what they talked about are things that are relevant to what I'm going to talk to you about as well. Hopefully we don't overlap, we complement each other. But my first question for you, since I need to engage you, because otherwise we're all going to fall asleep because it's the end of the day. How many of you in your practice deal with privacy issues? A decent amount, I guess I'd say 30% or so. How many of you specialize in privacy? Beware before you answer, I'm going to make you come up here with me. One. Did I see one person in the room? Okay. Do you love it? Been doing it for a long time? Pretty long? So how many of you have found that privacy has become more and more a part of what you deal with or find yourself facing in your practice? A lot. Okay, so thanks for engaging with me. I mean, what I wanted to really share with you to get you started is that when I started dealing with privacy issues a very, very long time ago, I was really the only person dealing with them. In the US, there was somebody else dealing with them in the EU, and we happened to come together. That happened to be about 16 years ago, and things have changed dramatically since that time. And what I found really fascinating is that privacy, although it starts with the law, it's really a multidisciplinary function where the business, technologists, lawyers, certainly across the business, privacy specialists, need to come together in order to address things effectively. And so much is changing. And it's changing because there's complexity in terms of how the factors that really weave into this environment are changing. And so I thought I'd start with a couple of things to get us going and thinking about this a little bit better. So, let's see. How many of you have one of these? Everybody in the entire room. Anybody abstain? No, you can't live your life without one. Okay, me too. How many of you have one of these? Or something like it on your wrist? How many of you are pretty religious about following your sleep, how much you sleep, or lack thereof? Nobody. Somebody. Yes. How about your stress level? Do you know these things can tell you your stress level? Anybody do that? Am I the only one in the room? It's fascinating, believe it or not. Next one. How many of you have one of these? Couple? Those of us who stay in apartment buildings, I stay in an apartment building here. I work in an office building that needs one of these. So what about these? This one. Everybody know what it is? Yeah? It's Alexa. Yes. I was gonna give you an echo, but I figured we'd start with Alexa. Okay. What about one of these? Beautiful, huh? I don't have one of those. It's really nice, though. Anybody seeing a pattern yet? Do you have one of these? Yes? It's very nice. I don't have one of those either. How about this? This looks like a notebook, right? Somebody knows what this one is. One of these. Hopefully you don't have one of those, but they're in your life. One of these. In your life? You see them? This? This. What do all of these things have in common? They are all connected, and they are all collecting data all the time and are sharing it with various different parties, actually moving it all over the place. Oftentimes it'll be flowing around the world in just a matter of nanoseconds. And this is why, for starters, the discipline of privacy, the discipline of data security, as we heard earlier, is actually becoming so complex. It's because, unlike when I first started dealing with these issues, data are being generated all around us every day, volumes and volumes and volumes of it. And that creates a lot of challenges in terms of managing privacy issues effectively. So new technology, generating new data, collecting new data, sharing new data creates complex challenges for managing the issues around privacy. What's happening as a result, and many of you are probably dealing with this every day, is that organizations are realizing, and I think you heard about it a lot in some of the earlier discussions, that data is actually key to being successful. I mean, in the conversation we just heard from the panel, actually having data to better understand how you manage your legal department. We certainly know that data are critical to e-discovery, but in the general businesses that you advise, I mean, everybody needs data to help them better understand things like market opportunities, how to better design and develop enhancements to products, general research and development, business development, corporate opportunities, all of these things. I won't go through every single thing on this list, but if you advise people in any one of these areas of running a business, generally, privacy will impact something that you do. Mergers and acquisitions, the data sharing, when in an M&A context, absolutely generates privacy issues and can actually cause a lot of privacy challenges for organizations that haven't thought through those issues in advance of deciding they're going to engage in a deal. And as a result, we have a changing privacy landscape. So we heard a little bit, just an introduction for GDPR. All of you, everybody know what the acronym is? Or are there people in the room who don't? I feel like I live this every day, so I want to be mindful of the fact that not everybody hears the acronym 10 times a day. Does everybody know what it is? And please don't be embarrassed if you don't. Yes? Most people do. Okay, I want to take a step back and talk a little bit about privacy and the global landscape that we're dealing with. And so what I have here to show you is that the landscape has changed fairly dramatically over time, really starting with privacy laws, where we had the first privacy, or what's known as a data protection law, was in a German state, Länder, as they call them there. Actually in 1970 was actually the first what they call data protection laws. Here in the US, we had privacy-related requirements, certainly in the health and education context. The concept of some principles that I'm going to get to on the next slide, they existed around the same time, but the more comprehensive types of laws really started developing in the EU. At the same time here in the US, there was much more of a focus on the kinds of laws that affect certain types of more sensitive information. So obviously, we know about concerns about financial information. All of the breaches and things that have happened here in the US have shown us more concern about what can happen if your financial information is not adequately protected. Health information. Going all the way back to even before I started being involved in the privacy space, here in the US we were focused on health information. And so we started to build up at a federal level a series of privacy laws that are focused on different sectors. But we don't have a comprehensive privacy law. What we do have, and those of you who've been practicing know that we have the FTC's jurisdiction generally with respect to Section 5 and unfair and deceptive trade practices, which has been the basis for most of the enforcement that's happened in the US, at least at the federal level. We also have seen that happen with state, comparable state laws that are directed at unfair and deceptive trade practices. But states have done a lot more, and you heard about it earlier in the security discussion. We have 49 states now that have security breach notification laws. And it's that kind of law that started here in California in 2003 that has given rise in the US to a much greater focus on having an understanding of your data, and understanding of where those data are in the organization and what your potential risks are. And that's been good because in many respects it's actually helped organizations think about what they now need to be prepared with under GDPR. And so I'm going to talk a little bit more about GDPR. The other thing I wanted to say is that the European requirements, so in 1995, the European Union adopted, and there were only 15 EU member states at that time, it's now almost twice as many, only 15 EU member states at the time, they adopted what was called the EU Data Protection Directive. And that basically took a new approach to privacy at a much larger scale that made people concerned about moving data out of countries. And as a result, you had this focus of like the US, a little bit in Canada, more at the provincial level, and in the EU, a focus now in other parts of the world as you had more globalization happening, more people sharing data, thinking about consolidating data in warehouses, so a little bit more of a centralized functioning for HR systems within companies. People in other countries, regulators, businesses in other countries, started getting concerned about whether they were going to be able to get data from Europe. That in particular was what gave rise to laws in Latin America. And so, for example, Argentina, Mexico, just to name a couple, adopted laws being mindful of whether they were going to be able to get data out of the EU. The same sort of thing happened in Asia. We've had just in the last few years a rapid expansion of the kinds of laws protecting privacy amongst a lot of the different countries in Asia. Even China this year, many of you have probably heard, there's been much more of a focus on cybersecurity there and laws that are being brought up in more a way kind of like how we do develop legislation at the federal level here that is sectoral in nature but tends to also have an expansive application. And so there's a lot of focus now on what does that mean for doing business in China. The more and more we become globalized and data gets shared everywhere, it gets collected everywhere, it gets shared everywhere, and it can happen very quickly, the more all of this becomes interconnected. And so oftentimes people like myself spend time sitting with regulators talking about how you're possibly going to be able to address the legal requirements for all of these different jurisdictions at the same time. And in order to be effective at that, I'm going to go back to a comment that was made in the last panel. You need to be able to think not only as a lawyer and interpreting the law, but how to make this real for companies. Because there is no way that you can limit the liability for a company strictly through giving good advice to everyone, because the data are everywhere. They're pervasive. And so every single person that's touching them, that's making that decision to acquire or divest, that's making a decision to outsource, that's deciding to stand up a new project or experiment on some new technology using, or some innovative idea they have using data that's sitting in some database somewhere else, all of those people are making decisions every day within businesses that may result in significant liability, especially under the new GDPR. So I want to talk to you a little bit more about that now. The common principles that have existed under privacy laws really since around the time I mentioned in 1970, they actually came together in a little bit more consolidated way in 1980 under what are called the OECD Privacy Guidelines. That's the short name for them. A number of different countries came together and established some core guidelines, and they really focused on two things. And these are the basis of what we have seen historically in most privacy laws around the world. The first thing are principles that are individual focused. So being transparent, or what we often call here in the US, providing a privacy notice or putting a policy on a website. It is very rare these days that we go to a website and there's not a privacy policy there that's addressed the core things that need to be disclosed in a policy. That's a core part of how people do business today, and that's a good thing. That's changed a lot since I first started doing this. The second thing, and what's very common in most places, is having a legal basis for the processing or use, collection, use, and sharing of data, because without that legal basis, you can be challenged under various different laws. I was at a conversation, I was not all the way in Germany like Eric was, but I was in Vancouver yesterday, and we had a debate at length about whether there are bases under lots of these different laws outside of the EU, because I'll get to the EU in a moment, for processing data. And processing, by the way, just means doing anything with data, altering it, changing it, retrieving it, collecting, using, disclosing, and all of that. But processing data without someone's consent, when is that okay? But legal basis for processing, and generally has been consent, has been around for a very long time. The other kinds of rights that people have had, and really California's led the way in this one too, at least in the US, is having rights to access data, to correct it if it's factually inaccurate. That's something that's very common in the federal laws, particularly under HIPAA as well. Having the ability to say no or opt out, so don't want to be part of that. We all get these emails and we say, stop sending me these spamming emails. That's our right that we're exercising to opt out that exists under the Can-Spam Act, for example. And the right to delete obviously has lots of qualifications associated with that. The other thing that's existed historically, and this goes back to the 2 panels before mine, around security, more data governance related obligations. And these are things like making sure you only are using the data you need to. It goes by different names. Here, sometimes we call it minimum necessary. In the EU, they call it proportionality. Quality and integrity of the data, making sure it's not getting altered in unacceptable ways. And of course, very importantly, security. Making sure data are properly secured from unauthorized access. So those are the core principles. There's hundreds of different laws. In fact, yesterday we were talking about over 121 countries at this point in time have some form of privacy law. In fact, many have multiple, whether it's a constitutional right to privacy that exists in many countries around the world, whether it's a federal, omnibus, broad, comprehensive law, or sector-specific laws. Many of them have all three. And then at the state levels or provincial levels in many countries. But what's different about GDPR, and I want to really focus in on this in the last few minutes, and how you, in every aspect of whatever kind of law you practice, how this is relevant to the way in which you're engaging, either with the person or people who are focused on privacy law, or as generally as you're thinking about advising your clients, how you weave privacy considerations into what you do. So GDPR has changed the paradigm. And it's changed the paradigm in the following way. First of all, unlike all of the other privacy laws that have existed historically, it actually can require organizations to be liable up to 4% of their global revenue. That is comparable to the competition law standards in the EU. That's actually where they got it from. They really have had concerns that companies have not taken this seriously enough. The thing is, they've also expanded the territorial scope. So if you do business with people in the EU, that does not mean you actually have to transact with them. You actually offer a product or service to them, or you're somehow monitoring their online activity, you're in scope. So all of those devices that I showed you early on that are collecting data, if it's about people and it's coming in from the EU, it's actually subject to the EU General Data Protection Regulation. So that's one key thing. The next thing, and these are where we expand beyond the principles, and privacy goes from beyond the legal obligations to a more operational component of what's necessary in the business, and actually takes on a compliance lens. And so I oftentimes equate what's now required under GDPR to what's required under the federal sentencing guidelines when we think about core components or essential components of an effective ethics and compliance program. You need to have good governance in place. There's this notion in the privacy space that they actually call accountability. It means lots of things in different places, but it's become very much of a focus and is actually embedded in the text of the GDPR. And what it means is you actually need to be able to ensure that your clients are able to demonstrate that they're complying with these requirements. The requirements include knowing where all your data are, what systems they're in, what countries they're in, what third parties are processing them. At any point in time, as of May 25th of next year, an organization has to be able to produce a record under Article 30 of the GDPR of all of its data processing. In addition to that, another thing that's very different and new is we think about risk, oftentimes we think about organizational risk, we think about legal risk, we think about financial risk, we think about operational risk. The risk that's different under GDPR, and it's more akin to what we think about in like the safety and the environmental context, is it's the risks to individuals. And in the EU, this is defined as the risks to the fundamental rights and freedoms of individuals. And if you're wondering what on earth that means, so are a lot of other people. It has not been all that well defined at this point in time, other than to say that there has been guidance put out. Basically says things that it's a lot like the risk of harm people are worried about under the security breach notification laws here in the US. Risk of identity theft, risk of fraud, risk of discrimination, so like we have under the anti-discrimination laws here in the US. So those are the kinds of things that they're especially concerned about. And for all of those data that you've identified or helped organizations identify, you need to know whether it's high risk. And if it's high risk, you need to assess it. You need to stand ready to document that you've assessed it properly and those risks have been effectively mitigated. So there's a lot of work to do. And without getting into a ton of detail about all of that, there's a couple of key things I want to leave you with to get this started if it's not already happening in terms of how you're engaging with clients today. So one is every business, in order to address these new requirements of GDPR, needs to be thinking about establishing some form of good governance. The way I like to talk about it is that the business, the leadership of the business needs to own it. And as lawyers, it's good to advise the business that that kind of liability means that the CEO, the executive committee, just like we were talking about the board of directors owning and being responsible for cybersecurity, board of directors needs to own and understand this too. It doesn't mean they need to deal with it every day, but it means they need to embed it into how they expect their organization to be performing. People can't just be moving data all over the place without understanding the obligations associated with it. And having good governance around that helps. Then it's starting and doing a basic risk assessment so you understand how to focus and prioritize. Obviously, every single data element that sits around a business is not going to be able to be focused upon at the beginning, but actually general risk assessment, where are our highest areas of risk, where might we have the greatest liability, that's a good place to start. The next thing, and I know for a lot of lawyers, probably not so much here, but I would say like in my experience a lot of times in the past, people who've been trained in the law are not always really comfortable with technology. Sometimes they are, and I would not suggest in any way that you're not. But I've had people say to me that I've practiced law with who said, yeah, but Hilary, I'm not really comfortable with the technology. What do you mean you want me to understand the way the mobile app works? You want me to understand that device and how it's sharing data? Yeah, we need to. Because if we don't understand the way the technology works, we can't give good legal advice. And so getting comfortable with technology, embracing it, being an early adopter of funny stuff that doesn't make sense, like the LiveScribe pen and the paper, by the way, that's what that pen was. If you've not seen one that actually it writes, actually records whatever you are writing, it actually, there's special notebooks for it. Next thing is, and I want to be mindful of the fact that it's almost time for your wine or beer, whatever the case may be at the end of the day, is actually advise on this thing I mentioned before to help with accountability, the program structure. Obviously, for organizations to deal with it, they're required under the law to have a policy in place, and it's not just that policy that's sitting on the website. It's how you're overseeing all of these standards for complying with your legal basis of processing, to go back to a point I mentioned earlier, as well as how you're managing third parties, how you're dealing with security breach. Security breach, I didn't highlight it on the last slide, but under the GDPR, all these breach notification laws we've been worried about here in the US that have very specific things like your social security number and your bank account number and your credit card number and your medical record number. Guess what? GDPR says all personal data subject to breach notification potentially. If any data, including your name, is subject to a breach, the company needs to verify whether or not that's high risk. And they need to engage, note, 72 hours, the regulator on that evaluation, and then determine whether or not individuals need to get notified as well. So there's a tremendous obligation to have policies and standards within the organization to be able to manage this effectively, and it's the part of designing that program and making sure that it's consistent with the legal obligations under GDPR that will help organizations to be effectively ready by May 25th, regardless of what new businesses they're acquiring and how things are changing. Advising the business on finding where those data are, that's a big part. So as you're engaging, whatever area of law you practice, make sure you're thinking about how to advise the business on the data. What data are you using? Doesn't mean you have to give the full legal advice on that, but understand that and then work with your privacy partners in your organization to address those risks. And then the last thing is this point I wanted to make about privacy impact assessments. This is where, once you know where those data are, it's very critical to go through and do an analysis of the risk and to verify that that risk has been appropriately mitigated. Now, as lawyers, you might say, but Hilary, that's really not what lawyers do. We certainly understand legal risk, but what do you mean? And so what I do mean is the following. The law has identified that there is a high risk that needs to be appropriately addressed with all of the data that are processed. The regulators have identified a way to do that, and they have actually given guidance for how organizations can go about and identify the kinds of compliance controls consistent with the law that will effectively mitigate those risks. And so it's very important to advise organizations to be doing that because they need to be able to show the regulators at any point in time how they've effectively mitigated those risks. So that's to get you started. There's lots more to do, but there's drinks to be had and a day to be ended, and I thank you for your time.